This is a meeting of the House Judiciary Non-Civil Committee. For those who may not be familiar, we're in special session right now. The call of the session does not provide the opportunity for us to move to vote on bills other than what is listed in the call. This particular issue is not listed in the call, and therefore we are not voting on it today. The purpose of this hearing, as we have on a couple of other occasions during the special session, is to air out some issues that we anticipate we may take action on in January. The environment, as you can tell, other than redistricting, is pretty quiet, and that provides the opportunity for perhaps a little more lengthy and substantive debate rather than the time confines that we unfortunately have to operate under during the general session. And of course, the next one is coming the second Monday in January. One of those bills that we're going to take up, and the subject of the hearing today, is House Bill 242, which is introduced by Representative Coomer. What we will do, and what I'll ask Representative Coomer to do, is to just take us through the substance of the bill. I'm not necessarily sure we have to do a section by section. We will at some point get to that. I think it's more constructive for us to look at it in terms of what does the bill address. There are some aspects of foreign law that we generally don't deal with here. So I think it's critically important to start from the beginning and to walk us through the state of things now and what possibilities exist as it relates to foreign law, and what this bill intends to do as it relates to that. And then I think what we'll do is just have questions from members. I know Ms. Travis has to leave when the civil meeting begins. Is that correct? But again, we're not voting on anything today. So if we have an interpretation issue, we can save that in case we don't have counsel in the room. So with that, let me just go. Oh, before I forget, let me recognize Judge Billy Ray from Gwinnett County, who's our judge of the day, who is not here. He's on his way. Okay. And we'll see him when he comes in. Representative Coomer.
Thank you, Mr. Chairman and members of the committee. House Bill 242, which is entitled the American Laws for Georgia Courts Act, really in spite of some of the hype you may have heard or others may have heard about this bill, is really not something very new. I told somebody today it's not like reinventing the wheel. It's basically kind of putting a new coat of rubber on an existing tire. And what I mean by that is this bill seeks to protect Georgians from the application of foreign law that is repugnant to our constitutional system. In essence, what the bill would do is allow a person to use reference to the bill as a way of avoiding having their Georgia lawsuit transferred out of this state and into a foreign court, particularly a foreign court that has a system of laws that is repugnant, again, to our constitutional system. There is already law in the books in Georgia called the Georgia Foreign Money Judgments Act, particularly OCGA Section 9-12-114, that sets out a similar standard with regard to domesticating foreign judgments and recognizing foreign judgments that are entered against Georgia citizens and Georgia corporations. And the framework there prevents a court from recognizing a judgment entered by foreign jurisdiction that does not recognize our constitutional concepts of due process and equal protection and so forth. It is somewhat different in that that law only protects a person who has already been sued and had a judgment rendered against him or her or it in a foreign jurisdiction. The House Bill 242 would act as a mechanism to protect someone before a judgment is entered while they're in litigation. Essentially what would happen under the theory of this bill is a plaintiff in Georgia sues a defendant in Georgia, but the defendant in Georgia asks to have the case removed to a foreign jurisdiction, typically on a forum nonconvenience motion, asking or explaining to the court that the facts of the case would be better heard in a foreign country where perhaps witnesses are located or perhaps the corporate defendant has some other interest, or maybe the plaintiff is a citizen of another country. And typically those would be valid reasons to move a case out of this country or out of the state of Georgia to a foreign country. But this bill would allow the non-moving party to raise as an objection to that motion the fact that the foreign jurisdiction, the target jurisdiction, has a set of laws that are repugnant to our constitutional principles. We see this come up in a number of areas. Domestic relations is one, divorces and child custody, where the parties perhaps live in Georgia, and then one party removes the children to a foreign jurisdiction in hopes of getting a better forum for their ultimate contest. And in particular, what we've seen in those cases is opportunities for a male party to remove the case to a jurisdiction where females do not share equal protection under the law. And so that has happened in some cases. We've also seen it. One of the examples that has come up is in the realm of workers' compensation cases. A foreign national working in the United States. And the example was from a case in another state where a foreign national was injured in the United States on the job. He had a valid, credible workers' compensation claim, but the instruction or the defense moved to have the case removed to his home country of Pakistan, where he did not live, but where he was a citizen, so as to substantially diminish the value of the claim, in the presumption that the Pakistani court or administrative agency would award substantially less than an American court or American administrative agency. So what we're talking about is protecting not just people getting a divorce, but also people with valid tort claims, contract claims, making sure that those claims are heard in a system where the American constitutional jurisprudential guidelines are in place. And this bill does not. Let me tell you a couple things it does not do. One, it does not have anything to do with other United States jurisdictions. So we're not talking about state to state. We're not talking about foreign jurisdictions. As we as lawyers know, foreign jurisdictions can mean another state. So this is not other American states or American systems. It's not the federal system. This is specifically defined as other countries, or the foreign laws are specifically defined as the laws of other countries outside the United States. So there's not really a full faith and credit problem. We're not talking about anything like that. This bill also, in spite of some of the discussion that has been in the media about this bill, is not a bill directed at any particular religion or any particular country or any particular legal system. In fact, there's a specific exclusion for religious church, religious corporations, associations, or societies, and making ecclesiastical or religious decisions. We're not talking about wading into that area. We know that the federal courts and the state courts have routinely said that those are not areas that civil courts are allowed to get into anyway. So we're not trying to go into that arena. And ultimately, this bill is only about ensuring that people, litigants in Georgia, are entitled to or are not deprived of their constitutional rights and privileges as either as Americans or Georgians or as people living in and subject to the laws of this jurisdiction. So that's it in a nutshell. I would be open to taking any questions or any criticisms at this time.
I think it's safe to say a purpose and a word I didn't use when we began the hearing was one of education. This is more of an education meeting than anything else about the subject matter. At least it is for me. I can't speak for others. A couple of questions. Under your legislation, if the moving party attempts to move and go out of country, does the party under your legislation, the objecting party, simply has the ability to object? Is it an ability to cut off the possibility of moving it to a foreign country, or does that still rest with the judge?
Well, The motion...
Walk us through the mechanics of that.
Plaintiff sues defendant in Georgia. Both are subject to personal jurisdiction in Georgia, but they have some connection to a foreign country. Defendant then moves the court to remove the case from Georgia to that foreign jurisdiction. Perhaps it's because there are witnesses or evidence in another country. Whatever the connection is, it exists. And there is, under current law, there's the opportunity for the judge to move the case to that foreign jurisdiction. Now, the judge is going to have discretion, his discretion now, somewhat. He's going to have discretion under this bill as well, he or she. But the difference is, if the non-moving party raises as objection to the motion that the target forum, would be one in which his or her constitutional rights would not be protected, whether that be freedom of speech, or whether there's no freedom of religion in that country, or whether there is no equal rights, equal protection under the law in that country, or whether there's a problem with due process. Whatever the constitutional issue may be, if the target jurisdiction is not going to, or does not have in place a way of protecting those same constitutional rights that we recognize, then the judge, in his discretion, can deny the motion on that basis. Now, one thing...
So it simply adds that criteria as an underlying basis for the judge to deny the motion?
Yes.
And that's all?
Yes. We are establishing that this is the public policy of the state of Georgia. That it is the public policy of the state of Georgia that in a situation where a litigant is trying to remove the case from Georgia to a foreign jurisdiction, it is the policy of the state to keep that case here if the target jurisdiction has a repugnant, or has a system of laws repugnant to our constitutional system.
But the judge is not, as a matter of law, is not forced to rule against the moving party. Is that correct?
You're right. In fact, we have a provision that says that if the judge rules in favor of the non-moving party, if the judge keeps the case in Georgia, you can just issue a decision, denying the motion. Doesn't have to give any explanation of that other than what he thinks is reasonable in the circumstances. If she grants the motion to remove the case, that is, she decides that the objection to the removal is not valid, or the problem does not rise to the level such that the non-moving party's constitutional rights would be necessarily violated, then this bill would require that judge to issue a written opinion setting forth findings of fact and conclusions of law as to why the judge ruled the way she did. So,
of course, as a practical matter, the parties would have to, the moving party have to show cause to begin with.
Correct.
Right. So, okay.
Right. The burden is going to be on the moving party.
Right.
This, if you think of it, if you think of this as, being on a scale, we're moving the bar ever so slightly. And a scale is not a good example, because I'm not talking about anything changing the weight of the burden of a moving party. But we're essentially, like I said, we are making clear the public policy of the state in this regard for the purpose of this motion. We want the legislative body to set public policy. We do not want the courts to set public policy. So this is our opportunity to take that bull by the horns and make sure that the courts are abiding by the public policy as we establish it as the legislative body in the state.
It is a statement of public policy. It doesn't rise to the level of a presumption that necessarily steers the judge in a particular direction, although my sense of it is, as a practical matter, that they would be taking notice of it. Would that be an accurate description, in your opinion?
Yes.
From an operational standpoint, from a how the case moves or doesn't move standpoint.
Right. Okay. You could say we're raising the flag for the judge. I mean, we're kind of highlighting this issue and giving a non-moving party, giving the party who seeks to keep the case here in Georgia, a little more meat to their argument. We're saying we're going to let them go into court and say, Judge, it is the stated policy of this state to keep this case here, because if you send me to country X, I'm not going to have these constitutional rights protected, and I'm going to be discriminated against because I am in category why.
So it gives them something. It gives the judge more to think about, but doesn't tie their hands. The bottom line.
Does not tie their hands.
How many states? I don't know if this is based on a model law or if it's based on another. Let me ask you: is this particular draft based on another particular jurisdiction's law? The second part of that is how many other states have adopted something similar?
Okay.
Understanding that similar, there are inherent differences in the word similar.
Right.
Okay.
There is a model piece of legislation that is promoted or I guess supported by the Center for Security Policy, and this bill is very similar to their model legislation. It does have some changes that we've made here locally to make the law more applicable to what we want here in Georgia. And the bill that was supported by the Center has passed. My understanding is that it has passed and been signed into law in 4 states. It has not been challenged. It's not been challenged in court in any of those states. It is currently in the legislative process in, I believe, another 8 states. In several of those cases, it has passed one chamber or the other, and will be up for consideration in the other chamber in the coming year. This is not, for clarification, this is not really nothing like the Oklahoma constitutional amendment that got so much attention a few years ago when the federal court struck down the Oklahoma constitutional amendment that had to do with certain aspects of religious law. This is I mean, in my opinion, this is a completely different issue. So I'm not really sure how in some of the public discourse we got way down the path of talking about this being a bill that would have some discriminatory impact on any particular group or religion or system, because you can read the bill, and any of those detractors I have asked, tell me what part of the bill you have a problem with. First question is, did you read the bill? We got used to asking that question with regard to House Bill 87, and if the answer is no, then we can educate them, and I have been able to do that. If the answer is yes, then I ask, what part of this bill do you have a problem with? No one can point to any particular provision.
That's a point well taken, and that applies to any piece of legislation. We don't vote on ideals. We don't vote on that which is uttered in 7.5 seconds on the evening news. We vote on words on paper.
Right.
No more, no less. And if there's an interpretation issue, then people like Billy Ray get to take a crack at it, and then ultimately, if there's a gap, we come back. And that's the way the process works. So that's a good point for me to ask members of the committee if they have any questions. I know we don't have the electronic system in this room, so I'll just have to do a visual if anybody. Mr. Ramsey.
Representative Kimmer, is there any? I've never been involved in a case where there's been an issue related to removing to a foreign country. So I've just never litigated that before. Do you have any case law that kind of fleshes out what judges consider under kind of within their current discretion when such a motion is filed? What they consider and what principles might guide them? I'd just be curious to kind of see, what judges are thinking out there right now, what kind of precedent is out there, and how the courts are dealing with. I certainly, if I was a party, I would certainly raise issue that the jurisdiction they're trying to get a case removed to has law that is repugnant to the Constitution. I'd certainly raise that, and I'm just curious if that's been discussed in a court case in Georgia. So nothing today, but between now and January, I'd be curious if you have anything that'd be great and helpful.
One thing I would say in response to that is, we're going to be dealing in the trial courts, and as you're aware, trial courts rarely, if ever, have published opinions in this state, and they do occasionally, but I doubt we'll find a published case on that point. But we can certainly see if there are any appellate cases that flesh out whether that's been considered and how it's been dealt with in the courts. I would tell you that Most of the information that I've read about this issue in particular has been from other states in the country. I don't have any specific cases I can cite today. There may be some that we can come up with before January. But as of right now, today, I don't have any. Let me, before I move on, recognize a couple of folks who are here to help me today, if I may, Mr. Chairman. Stephen Gillay is an attorney from Louisiana. He helped with the Louisiana draft of the bill, and he's here to help me. If I could have him come up, he may be able to discuss that issue. And while he's coming, also Christopher Holton is here from the Center for Strategic Policy, and Chris, if you just back there in the back. These guys are kind of the functional experts on this this bill, this subject matter. So I'll let you address it.
First, I'd like to clarify that I'm barred to practice law in the state of Louisiana, not the state of Georgia, although forum nonconvenience is pretty standard across the United States in most state venues. I believe your question was directly directed to what is the current standard of forum nonconvenience and how would this bill change that standard, or anyway alter that standard. Typically across the United States, forum nonconvenience is based on the type of considerations which the representative very aptly noted, such as the availability of witnesses, the closeness of the action, the relation of the action to the other forum. What this would add is a consideration of the fairness of the other forum. There's one case nationally where this has sort of been explicitly dealt with that I'm aware of, and that's out of California, where a woman was injured in an Arabian country at a resort, severely injured. She was a Californian. She went back to California. There was personal jurisdiction in California over the defendants that were in Arabia, so they were able to sue in California. They had personal jurisdiction. The issue of forum nonconvenience was brought up, though, because they argued, well, the incident occurred in Arabia. Shouldn't this matter be adjudicated in Arabia? And her defense to the motion of forum nonconvenience was no, because it was a tort claim under that particular country's law. A woman only receives half of the value of a claim of a man. She stated that was discriminatory against women, and therefore this case should not be dismissed out of California and be adjudicated in Arabia. Instead, it should be adjudicated in California. And the California Appellate Court agreed with her and denied the motion for forum nonconvenience. This bill would just simply take that policy position that was taken by the California Appellate Court and write it into law. So you, as representatives of the people, can state the people's will that the people of Georgia do not want cases transferred to jurisdictions in which the value of a woman is half of the value of a man, or some other policy or procedural difference in that other forum which would not in any way be consistent with the policy or the constitutional rights of Georgians.
The California court made that ruling without having any provision in their code such that we're discussing today. Is that a correct statement?
I honestly cannot answer that question because I'm not sure what codal provisions they referenced in the California Code. There was not a form of the American Laws for American Courts Act in California, but there may have been other considerations either in California case law or in California codal articles. And frankly, right now, without the case in front of me, I can't comment.
That would be interesting to know. Just, not tomorrow, but when you get a chance.
Many of the concepts included in the American Laws for American Courts Act have similar corollaries in existing law, but this clarifies it. And although the California case had a happy ending for the California plaintiff, there's been many other cases across the country in different circumstances where the courts have not applied what we would hope they would have applied regarding foreign law.
So you have American courts that have removed cases to foreign countries where the party that had opposed the motion for the removal essentially got treated like half a person or something of that.
Not only in the forum nonconvenience application, but also in the application of enforcement of a foreign judgment.
Well, I guess my question is, do you have specific? I'm asking for specific examples. Again, not this second, but
sure.
at a future time to supplement the materials that we have about real life examples of where this has happened, so that just for the committee to review and digest.
There are dozens of real-life examples where foreign courts have applied foreign laws which we would generally think are not consistent with our public policy or with our constitutional norms.
Okay. Members of the committee? Okay. Thank you both very much. I think what we'll do is, we're in good time. I wanted to go ahead and ask Representative Coomer, did you have anyone in specific that you wanted to recognize to give testimony, or I was going to open it up?
No, you don't open it
Okay.
up.
Yes, sir.
I will ask a question.
Fire away.
Okay.
Go ahead. Just go ahead. You pull the mic and click it on if you can.
What's the argument, frankly, for disputes that occur geographically in Georgia to not always have Georgia as their designated place of jurisdiction? When does it make sense from the perspective of us as policymakers and our citizens to have a case be taken overseas and adjudicated elsewhere?
Well, you know, we're talking about motions for forum nonconvenience, and it's easy to consider or easy to imagine a case where it would be appropriate for because the witnesses or the evidence or other interested parties are in France, for example, and so we're not. This bill is not seeking to say that we should never have a case go out of the state of Georgia. It's simply saying that if you want to take your case out of the state of Georgia, and you want to take it out to a country that doesn't recognize the same constitutional provisions and protections that we do, then the judge can deny your motion, and this kind of sets out a starting point for that argument for the party in the case. So we're not saying that no cases should ever go out of Georgia. We're just saying that Georgia litigants, plaintiffs in particular, should have this protection. Should have this protection in place before they're required to go out and defend a suit in some other country that doesn't have our same protection.
I mean, I would contend, and maybe I'm right, maybe I'm wrong, but I mean, I think you could construct a pretty strong argument to suggest that, at least for some categories of cases, that the rights that we enjoy as Americans and as Georgians are generally not as well respected in other places as they are here. I mean, I could really there may be a number of judges in Georgia that would view the European Union's respect for parental rights or the respect for certain familial relationships to be, consistent with our Constitution. But I could make a very strong argument, I believe, if I were able to prepare, that that's not the case. And it would seem to me that in this case, to me, it ought to be the policy of the General Assembly and the state that there ought to be a justification if a case is allowed to go overseas, that the burden of proof ought to rest squarely on the person who's making the case, that jurisdiction fully and completely recognizes the rights like we do in Georgia and like we do in the United States. To me, this isn't a strong enough statement. The burden, it allows one party that's seeking to keep it here in Georgia, it allows them a venue to kind of tell their story and make their case, but it still seems that the burden rests on them to make that case. It seems to me the burden ought to rest on the person that's seeking to take it overseas to demonstrate that the European Union respects the parental rights like the United States do, or to demonstrate that the Kingdom of Saudi Arabia recognizes the rights of women like they do men. That the burden ought to be squarely on them, and I'm not sure this does this as strongly as perhaps I think it ought to.
Well, and you may be getting into a distinction between burdens of proof and burdens of persuasion, and ultimately the burden of proof is still on the moving party to prove that they should have their case removed to another jurisdiction. One of the things that we do here in this bill is we require the judge to explain, put pen to paper, and publish an opinion that goes in the clerk's record to explain why they ruled against a party who says, if you send me to that court, I'm not going to get a fair trial. The reason for doing that is so that, frankly, judges can have an opportunity to explain why they did what they did, and more politically, they can be held accountable. The judges in this country, or in this state, are elected, and if a judge is making rulings that are against the interest of people in his or her jurisdiction, in his or her county, it won't take long for the citizens of that county to realize what's happening, and particularly if the judge is having to sign his or her name to an opinion that the community finds to be offensive, then this bill helps and aids in holding that court accountable for those decisions, making sure that they're not secretly thwarting public policy. They're going to have to do it openly.
Well, and I appreciate the gentleman's sentiment. I mean, again, I know you're trying to move the football in this bill. I guess my concern is that it'd be very easy for a judicial actor to say, you know what, it's my opinion that this jurisdiction recognizes these interests adequately. I mean, it's not, and they could very easily say that in a way that's not going to expose them to kind of any claim of misconduct or whatever. They could, with a straight face, make a case for many jurisdictions. I'm just concerned, we use the case of parental rights, we use the case of custody issues. I just believe that if you were to poll this is completely speculative, but I would speculate that at least a third of the judges in the state would stand behind the UN Convention on the Rights of the Child, which is a framework that's been adopted by the European Union. It's case law in most of Europe that puts the parent here, the child here, and the government as the referee of the parent-child relationship. We can go on and on and on about what that is. Many states, most of the nations, just as a kind of a tip of the hat to the UN, have done that, have ratified this over the last 18 years. But it is in direct contravention to our understanding of parental rights, and it'd be very easy for a judge to say, "Hey, I think this other jurisdiction's view of the relationship's adequate," and they could stand behind it, and there'd be others that they wouldn't be out there on a limb on their own, certainly. And I'm just concerned that we perhaps ought to strengthen this in a way that really makes the burden of proof rest on the person to demonstrate substantively and objectively that the rights are as well recognized overseas.
Let me, anything else from members of the committee? Seeing none, I have a witness list here. There's no one on it, but let me, since people are here, if anyone would like to weigh in on it, let me just remind folks, if they are going to offer some testimony, that this is not, again, we are not acting on this bill today. This is a hearing, and it's more of a dialogue, I think, more than anything else, and that's time well spent. So this is a hearing only. Is there anyone in the audience who'd like to be heard on it? Going once? Going twice? Okay. Representative Coomer, thank you for bringing the bill. I think it was a very interesting discussion. If interested parties are interested in supplying the committee, either by and through me or individually, with supplementary materials setting out positions on it, we always welcome that, no matter what the legislation may be, and would ask you not to hesitate, whether you're pro or con. I would ask, I think that information that we asked for earlier, I think is relevant whenever that's convenient, and we'll just march on from there. So, thank you for your time today.
Can we get on a list?
Yes, ma'am.
Can we get on a list to get emails about upcoming hearings?
Yes, ma'am. You can go ahead and call. Yes, ma'am. You can call my office. That number is 404-656-5943. And you can speak to my assistant, and anyone can be added to the email distribution list, and we send those out for all meetings whatsoever and all announcements, and that just goes out as we schedule them, and it goes out immediately electronically. Yes, ma'am. 404-656-5943. Yes, sir. Oh, I'm sorry. Thank you, Representative Atwood. The General Assembly website is the House website is, which is the important website, is the www.house.ga.gov. That's really helpful for legislative tracking because, of course, legislation goes through many iterations as it goes through the process, and you can see the latest and greatest drafts as bills make it through the process. But in terms of meetings, hearings, and schedules and getting notice of those on a timely basis, being on the email list is absolutely the most efficient way to do it. Sorry? No, this draft will not be, but the bill as introduced would be. A committee, we're working on a committee sub that wouldn't be on the website unless we went ahead and passed it out, and of course we're not acting on anything today. With that, I thank the committee for its attendance and its attention, and we're adjourned.